on.
Welcome, everyone. Good morning. My name is Jamie Schenker-Presero. I am the Associate Director of Temple Small Business Development Center. We assist small businesses start and grow, and we are doing this virtually through consulting that can happen over the phone or over Zoom, and with a full roster of online trainings like this one today. And at the end, I will go over some of the other events that we have coming up that might interest you. So let's see. Great, we have a lot of people in the room. Thanks for joining us. Today's presentation is going to be on the trademark applications and some mistakes that attorneys see, and specifically with the Internet of Things related industries, because we're seeing a lot of that. A lot of e-commerce, a lot of people getting their business online. That's what we're seeing with the pandemic. So maybe that applies to your business. And today we are so happy to be joined by Dana Dixon of Dana Dixon Law, and she'll be doing today's presentation. We have everyone muted, and we encourage you to put questions into the chat and the Q&A, and we'll get to them at the end. I would ask that the questions be generally applicable. We don't want to get into specifics, and that's for your own safety and confidentiality, and also just for time, because we have limited time with Dana, and we want to make sure that the questions will apply to more people. So hopefully that makes sense. We'll put a little survey in the end for you to complete, and we'll also put some resources in the chat for you that we've been collecting. So I think I will hand it over to Dana. Thank you so much again for being with us this morning.
Thank you very much for having me. I appreciate it. So I am going to talk today about common issues that come up in trademark applications. I have been asked to focus on the Internet of Things, so we are going to keep focused on that. But a lot of what I talk about will be generally applicable as well, if maybe what you are doing does not fall exactly within that category. A tiny bit about me. I am a solo practitioner. I specialize in trademark law. I file applications to register trademarks for entrepreneurs, small business owners, but I used to work at the US Patent and Trademark Office reviewing trademark applications all the time. So basically the same job, just the other side of the desk. And in that position, unfortunately, I had to refuse a lot of the applications that I reviewed. Not something I ever enjoyed. I don't like raining on anyone's parade, but unfortunately, there are just a lot of issues that can come up in the process. So I always start these presentations just by mentioning that and trying to give you an idea of what is normal, because sometimes people are thinking, okay, well, I'm dealing with a government agency, trying to get a registration. It'll be kind of like going to the DMV. As long as I have my paperwork in order, then everything's going to be fine. So I just want to start by saying, the trademark application process is a little bit more strict than that. So I pulled these statistics from the USPTO website, and you can see T's standard and T's plus. These are just two different types of form that can be used to file an application online. And over 83% of these are not approved on first action. So that means they have at least one problem, sometimes many problems. So that's just to give you a sense of what is normal, what to expect in the process. Now, given that there are so many different issues that can pop up, and we have about an hour together today, we are not going to be able to cover every single one of them. We are really just going to hit the tip of the iceberg. But I do hope by the end of this, you will leave with a lot of helpful information. So just to give you an idea of where we're headed, we're going to start by talking about what a trademark is. And this is just so that we're all on the same page. We're all thinking about the same thing when I say trademark. And then we're going to go down to what I call the big two. These are the two most common refusals issued by the USPTO. And then another section that I'm going to call the smaller three. These are three issues that pop up all the time in applications related to the Internet of Things. So three things you definitely want to look out for. And then hopefully we'll have plenty of time down here for questions. So let's jump right in. what a trademark is. A trademark is a source identifier. And if you remember nothing else from this presentation, please remember those two words. They're so important, source identifier. Okay, so what that means in the real world is that a trademark is just a shortcut that we as consumers use all the time, every day, to get more of the things we already know we like. So I'll give you a kind of quick and silly example, but I love McDonald's French fries. They are one of my guilty pleasures in life. I know they're horrible for you, but they taste amazing. So if I've had a rough day and I'm driving around and I'm looking for some comfort food, I'm going to keep my eyes out for the source identifiers, the trademarks that will help me get to those fries I know and love as quickly as possible. Now, that might be the word McDonald's, it might be the Golden Arches logo. Either way, when I see one of those things, I know I can turn in there. I'm going to get the fries I want. I don't have to drive around to 4 or 5 different restaurants and order the fries and see if I like them. Okay, so that's how the trademark works. It helps the people who want what you have on offer to find you. So when you think about trademarks, you want to think about things like slogans, logos, product names, names of service providers. These are some of the most common trademarks. There are other things that can function as trademarks, and we may talk about them a little bit later in Q&A, but these are by far the most common ones. Now, I am taking you to the one and only flowchart slide of this presentation. So if you hang in here with me for about 2 minutes, I promise from here on, it is all downhill. And there will be a lot fewer arrows on any given slide. But I just want to give you a sense of what the application process looks like in general, big overview, and then what you get at the end of it. Why do people bother to go through this? So in the beginning, you have a mark. Now, if you use that mark with goods, technically it's called a trademark. If you use that mark with services, it's called a service mark. I bring this up just very quickly in case you get a communication from the USPTO and they refer to a service mark. That means exactly the same thing as a trademark. It's just that you're using your mark with services. That's the only difference. For purposes of this presentation, I'm just going to keep saying mark or trademark, whether I actually mean trademark or service mark. It's just easier for everyone involved. So you have a mark and you want to protect it. You file an application to register your mark with the USPTO. That's the US Patent and Trademark Office. It's a federal government agency that exists in large part to review applications just like this. Now, what they are not is the trademark police. So, if you get a refusal from the USPTO, that does not mean anyone is coming down to your place of business and telling you to shut it down. All they are saying is just they cannot register the mark on the federal register. Okay, so that's all they do. It's very limited in scope. So you file your application, and it takes about 3 or 4 months from the time that you file until you get a response from the USPTO. Now, what happens at that stage is an attorney at the USPTO reviews your application, and they are looking for any of dozens of potential issues or errors. And they're also going to search the Federal Register for similar marks. Now, the Federal Register is just this enormous database of all of the trademark registrations that the USPTO has granted in the past. So they're going to do a search for your mark, whether that's wording or a design or both. And they're going to see, does anybody else already have a registration for this particular mark or something very close to it? Are they using it in a field similar to yours? If so, then you will get a refusal. It's called the Section 2D likelihood of confusion refusal, and we will talk about that more in just a few minutes because it is the #1 most common refusal issued by the USPTO. But for purposes of this slide, we're going to say they don't find any similar marks in that search, and there are no other problems with your application, and it is approved. So you will remember from a couple of slides back, that is the exception to the rule. Over 83% of these applications that are filed online have at least one problem with them. But the good news is today we all get to be exceptional. So we're going to go straight through to approval. And I want you to notice that approval is not the same thing as registration. We are not quite across the finish line just yet. So what approval means is that the USPTO says we don't have any problem with this application going through to registration, but we are going to now open this up to the public. So there is a 30-day window called the opposition window, when anyone in the general public can file an opposition to the registration of your mark. Now, usually that would happen if someone has a mark that is similar to yours. They're saying they were using it before you were, and they really don't want your mark to be registered. This usually doesn't happen, okay? This is the exception to the rule that someone would file an opposition. It costs them hundreds of dollars to do it. That's just to file it, much less to follow through with that whole process. But it does happen from time to time. So just something to be aware of. If you get through that 30-day window and no one opposes you, then the mark registers. Okay, so what do you get now for all of your time and trouble? You get many benefits. I'm just going to focus today on what I consider the top three. And the first is that you get to use this circle R symbol. Now, before you actually have a federal trademark registration, you cannot use the circle R symbol with your mark. You can use TM or SM beside your mark, but you can't use the circle R until you actually have that federal registration. So you may be thinking, well, what do I care if I get to use the circle R symbol? Here's the thing, it puts people on notice. So if someone goes on your website or they look at your product packaging and they see the circle R, they know you have that federal trademark registration. And if they were thinking about using something similar, hopefully this makes them back off and they say, you know what, it's not worth the hassle of having a protracted legal dispute with someone over this mark. We'll go back to the drawing board, we'll come up with something different. So it has what we call a deterrent effect. All right, your second big benefit is that your mark is now in the federal trademark database. Well, what does that mean? Let's say you have your registration today and 3 weeks from now, 3 months, 3 years from now, whatever the case may be, someone else files an application to register your mark or something really close to it. Well, that application is going to go through this whole process that yours went through. And when we get to this part where that attorney at the USPTO is reviewing the application, they're going to search through the Federal Register. And if that newcomer's mark is too close to yours, your mark is going to pop up in that search. And then the attorney at the USPTO will issue that refusal and say to this newcomer applicant, too bad, so sad, you got here too late. Someone else already has that mark registered. So that's really good for you. You definitely don't want someone else to get your mark registered. Okay, and then your third big benefit is that there is a legal presumption that you are the owner of this mark. So without getting bogged down in detail or hyper-technical about this, basically it just means if you ever do find yourself in a court arguing with someone over who is the rightful owner of this mark, you will be given the benefit of the doubt in the sense that the evidentiary burden is on that other party. They face an uphill battle. And if you think about it, that makes a lot of sense because what the court wants to know is to this party challenging you, well, you had an opportunity to speak out at this opposition point. This other application went through this whole process. You had the 30-day window. You didn't say anything. So if you really were using the mark back then, why didn't you speak up? So they have an uphill battle, and hopefully you will never find yourself in that situation. But if you do, you'll be very glad that the burden is on the other party and not on you. Okay, let's talk for just a couple more minutes about what that federal trademark registration means for you, if you get it. It means you have the exclusive right to use your mark in connection with your identified goods or services throughout the US. The part of this that sometimes surprises people is in connection with your identified goods or services. So sometimes people call me up and they think, okay, if I get my registration, I can use that mark with anything under the sun, and I can prevent other people from using that mark with anything under the sun. It does not work that way, okay? So when you apply, you have to specify what you are using your mark with. Remember, it's supposed to be a source identifier. So it has to identify the source of particular goods or particular services, and you have to say which ones. And then that is going to determine the contours, the borders, the boundaries of the protection that you get. And we'll talk about this more as we go along. But basically, you are getting the chance to put that circle R symbol on those goods or near a description of the services that you have identified. And then you are getting a zone of protection that extends a little bit beyond that because other people who want to register a mark similar to yours can't use it with your particular goods or services or goods or services related to them. So we're going to talk more about how we know which goods or services are related and kind of how far that expands. But just to give you a heads up, the protection is limited in that sense. It's not for everything that you could ever possibly imagine doing or selling. Okay. You also have to, on top of identifying your goods or services, put them in the correct class. So a class, this will just show you, we have 45 classes of goods or services that the USPTO uses. And each class has a heading. Sometimes the heading is helpful, sometimes it's not, but everything that you could do or sell has a proper place within this scheme. So I'll give you a couple of quick examples just so you can see how this works. My legal services are always down here in class 45. You can see the heading personal there would not really help you to figure out what belongs there. And actually in practice, this class 45 is kind of like the drawer in your kitchen where you throw everything that you don't know where else to put. That's kind of where all of these services that they don't really know where to put end up, is in class 45. But another quick example here, if you had, let's say, a mobile app for home automation, that would go here in class 9. That's where our downloadable or recorded software belongs. If you have software for the exact same thing, but it is non-downloadable, so cloud-based, you'd be over here in class 42. If you have non-downloadable software that's for games, you're actually up here in class 41. And these are kind of strange because you'll see 41 and 42 are actually services. They're not goods. So technically you're registering not that software, but the service of providing temporary use of non-downloadable software. So it's not even always super easy to figure out whether what you are doing is a good or a service. But the reason why this matters so much is because the total number of classes in which you identify goods or services is going to determine the total amount of filing fees that you would pay to the USPTO. So it's per class. And a quick example of how this works, if you had that home automation software and you had a downloadable mobile app for it and you were in class 9 and that's all you used your mark with, then you would pay one filing fee for one class of goods, and that's it. If you had that software and you have the mobile app, but you also have the non-downloadable software for the same purpose, well, you're going to have class 9 and class 42. So now you're going to pay twice as much in filing fees. And if you have 5 classes of goods and services, you'll end up paying 5 times as much. Okay, so that's one of the reasons why it's important to figure out the correct classes, the total number of classes that your goods or services are in. Now, that's a lot of information. Hopefully this will make more sense as we go along, but you will hear me say classes and goods and services about 1 million times in the rest of this presentation. So now you know what I'm talking about. Okay, let's move on to the big 2, our second topic. These are the 2 most common refusals issued by the USPTO. And sometimes these are very short. Sometimes they are 10 or 12 pages long with another 30 pages of exhibits. And people read through the whole thing and they get to the end and say, I have no idea what this is about. So it may not come as any great surprise to you. Attorneys are not always the very best writers or communicators or even trying to be either one of those things. So my goal today is just to kind of break down what these 2 refusals are about so that if you end up getting one of them, you will understand what the issue is, but also hopefully you will avoid getting one to begin with.
Dana,
all right, so yes.
We have a question. Will patent application process will also be discussed?
I am not talking about the patent application process today, no. So I only do trademark law, 100% trademark law. I don't do patents. When you work at the USPTO, you're on one side or the other. So even though it is the Office of Trademarks and Patents, you either do trademarks or patents and not any crossover between the 2. Okay. So the number 1 most common refusal is the Section 2D likelihood of confusion refusal. This just means that somebody got to the party before you did. Someone has registered either your exact same mark or something very close to it in a field of use that is related to yours, and This is pretty much every business owner's nightmare. And this is also why people who are involved in trademarks or branding are kind of obsessed with searching. They'll refer to this sometimes as clearance searches or just searches. But basically what they're talking about is trying to get an idea of if there is anyone else out there who is using your mark or something very close to it in a way that's going to cause a problem for you later. That problem might take different forms. That problem might be just blocking your path to getting a federal registration of your trademark. That problem might be somebody contacting you with a cease and desist letter or suing you because they believe they were using that trademark before you were. And then you have two not great options, which is, do I want to try and fight over this in court, which can be extremely expensive and take a long time? Or do I want to go through a forced rebranding, meaning I have to now scramble to come up with a different mark. I have to try and take my mark off of all of the places where it currently appears. And I have to get other people familiar with my new mark, and all of that time and energy and money that I spent in developing goodwill around this particular mark is basically just sunk, right? So that's what the search is all about. It's trying to avoid those kinds of problems. So when we're talking about the search, what are we even looking for? Well, we are looking for marks that are confusingly similar. That is the legal phrase you will see over and over again. But the best way that I can kind of break this down into real world application is just this question. Would the average consumer who sees your mark used with your goods or services and the registrant's mark used with their goods or services be likely to think those goods or services came from the same source? We're always concerned about same source confusion. A quick note here, registrant is just what the USPTO is going to call that person who holds the registration that might be blocking your path to registration. When you file an application, you're going to be referred to as the applicant. So those are the two terms they're going to use over and over again, applicant and registrant. All right, so let's put this into super concrete terms. If I walk into Target and I see your mark on a bottle of ketchup and the registrant's mark on a bottle of mustard, am I likely to think that ketchup and mustard is being sold by the same company? That's it. If the answer to that question is yes, then the marks are confusingly similar. So I've tried to make that sound as easy and straightforward as possible. In practice, this is one of the hardest parts of trademark law, is figuring out whether the marks are confusingly similar, making the argument for or against. I'll give you a quick example where we don't have confusion as to source. Sometimes it is helpful to see a line in the sand, helpful to hear a negative. So we have Delta Airlines and we have Delta Faucets. And these two companies coexist peacefully in the marketplace, even though they're using basically the same mark. They are not at each other's throats, arguing over who gets to use it. The reason for that is basically we don't have confusion as to source. No one is walking into Home Depot and picking up that Delta Faucets box and thinking like, wow, the airlines people have really branched out, and vice versa. So because they're operating just in such different parts of the marketplace, we're not confused about source, so there's really no problem. All right, so when we're thinking about whether there is a likelihood of confusion as to source, we have two main concerns. And to be very, very clear, I am talking about just the context of that attorney at the USPTO, what they have in their mind. So there are some other situations in trademark law where other factors might be more important. But just in terms of what that attorney at the USPTO has in mind when they are sitting at their desk looking at your application, they have two main concerns. The first is how similar are the marks? And the second is how closely related are the goods or services? Now notice I said similar, I did not say identical. The marks do not have to be identical for this to be a problem for you. If they are identical, yeah, that can for sure be a problem. But you also want to look out for marks that maybe are just slightly different spellings, maybe one or two letters difference in the mark. Marks that maybe have bigger differences in terms of appearance, but that sound the same. That is a really common problem. Or even marks that have bigger differences in sound and appearance, but that put the same overall idea or image into your mind. So the classic example here is Blue Chapel versus Blue Nun. And the USPTO refused in this case. They said that these are too similar. And yeah, we know that chapel and nun don't sound or look at all the same, but it's blue plus something religious. We just feel like that's going to be too confusing for people. Okay, so just be aware the marks don't have to be identical for this to be a problem for you. You also need to look out for similar marks. All right, down here with goods and services, again, I did not say identical, I said closely related. So the goods or services don't have to be identical for this to be a problem for you. If they are identical, yeah, that can be a big problem, but you also want to look out for 3 other main ways that goods or services can be closely related. The first is if we know that companies commonly sell both goods or offer both services under the same mark. So as a quick example, if you were trying to register your mark with thermostats and someone else had already registered that mark with smoke alarms, you'd probably get a refusal there because we know a lot of companies sell both of these things under the same mark. Nest comes to mind very quickly, but lots of other companies do that too. Okay, so under those circumstances, we just think this is going to be confusing. A second way that goods or services can be closely related is what we call trade channels. So that just means that you get both of these things commonly in the same place. To be very clear about that, I don't mean like, oh, you can buy both of these things at Best Buy or both of these things at Home Depot or at any department store. So we're not looking at big box stores like that or department stores like Macy's, because you can buy a little bit of everything in those places. That would mean that all goods and services are related, basically. That's not the kind of evidence we're talking about. We're talking about more specialized stores, whether those are physical stores or online stores. So, if you went to smarthome.com, and that is still, they're providing a number of different goods on that website, but it's a more limited set and it's all organized around a particular theme. It's a specialty store. Okay, so if your goods are in that particular website and the goods of the registrant are also in that particular website, well, then they're probably related because we can get both of these things in the same specialty store. All right. The third most common way that goods or services can be closely related is if we use these things together. This is called complementary use. So the classic example is peanut butter and jelly. But in the field of technology, if you think about something like doorbells and security cameras, these things are not only used together, I mean, they're commonly integrated into the same product now, where you buy the combo doorbell and security camera all together in one product. So when things are used together in that way or integrated into the same product, then we think it's very confusing for consumers as well. And just a quick note on that, all of these things change according to the realities of the marketplace. So, maybe 10 or 15 years ago, we would not have said doorbells and security cameras are related. But because these two things are now integrated into the same product very, very commonly, okay, it looks like they are related now. So just because something wasn't related 10 or 15 years ago doesn't mean you can bank on that it will never be related in the future. You really just have to look at the realities of the marketplace in that moment when you are applying. So I'm going to give you a quick example from real life. This was refused by the USPTO and then it was appealed and that refusal was affirmed. So we have on one side Caracas with a design, and on the other side Caracas, just the wording. Different spelling, but the USPTO said, you know what, we understand it looks a little bit different, and we also understand like this is a made up word, whereas this is a real word. This is an actual place you can find on a map. But still, I mean, when you say them out loud, they sound almost exactly the same. We just think that's going to be too confusing. And then for the goods, we had on one side chronometers and on the other side smartwatches. Now, these are not the same, right? These are not identical goods. They're actually not even in the same class. Chronometers are in class 14, smartwatches are in class 9. So you don't have to be in the same class for the goods or services to be related. But basically, the USPTO said here, yeah, but we have a lot of companies that sell both chronometers and smartwatches under the same mark. And we just think under these circumstances, it's going to be too confusing for people. All right, so Let's move on to our second most common basis for refusal, and that is the Section 2E1 mere descriptiveness refusal. Now, it is all in the name here. The problem with a merely descriptive mark is that it is not doing the heavy lifting of a trademark. The trademark, again, is supposed to be a source identifier. It's supposed to tell me where do I go to get the particular goods or services that I want. A merely descriptive mark doesn't tell me where to go to get those goods or services. It just tells me about them. So it's a little bit more complicated than that in practice, but given the amount of time we have together, like 80% plus of the time, that's what's going on with a merely descriptive mark. It's just telling me about the goods or services. So
Tanya,
I'll give you, yeah.
we have a question. So, is the trademark a one-time payment?
Okay, so a quick thing on that. You pay a filing fee for your application. How much you pay after that depends on the filing basis that you choose. So a really quick detour here, and we can talk more about it in Q&A if you want. But basically, if you are already using your mark in the real world, you can file 1A, and that just means I've got a specimen ready. The specimen is the thing that you submit to the USPTO that proves I'm using my mark out there in the real world marketplace. Consumers are already encountering my mark. So in that case, unless you have problems with the application, then you should not be paying any additional fees in that process to get to registration. If you are not using your mark yet, you have the intent to use it soon, but you haven't, started production or whatever the case may be. This is not actually for sale under this mark yet. You can file 1B, and that buys you a little bit of time to submit your specimen so that you can, get your product into production and actually be selling this within a short period of time after you file your application. When you get to the point that you're ready to submit the specimen, then you would pay, the fee currently is $100 per class. The fees are going to go up effective January 2nd, but that's how much it costs right now. So if you had multiple applications or if you had multiple classes within your application, it's going to be $100 times however many classes you have. You can also file requests to extend the deadline to submit your specimen. You can do that multiple times, and that costs $125 per class. And that fee is also going to increase next year. But those are the fees that you would commonly have to pay with the Section 1B application. Now, that's kind of generally speaking. There are some other things that can happen along the way where you might have to pay other fees. Once you get the registration, you have to maintain the registration. So basically, between 5 and 6 years out from when you get the registration, you have to file maintenance and renewal documents. That costs several $100s. And then 5 years after that, again, and then from that point forward, it's once every 10 years. So you do have to keep using your mark out there in the real world marketplace. And you also have to keep filing those maintenance and renewal documents and paying those fees for them. That's a really, really quick overview of how that works, but hopefully that answers the question.
Thank you.
Yeah. So our second most common refusal is the Section 2E1 mere descriptiveness refusal. Again, this is where you are just describing those goods or services to me. You're not telling me where to go to get them. So I'll give you a kind of silly example of this, and then I'll give you one that is related to the Internet of Things, specifically in his real world example. Okay, so my silly example is if we have delicious cupcakes and we're using that mark for cupcakes. All right, so this is not telling me anything about where to go to get the cupcakes I want. Cupcakes just tells me exactly what I'm getting. Delicious just tells me a feature of the cupcakes. They taste good. Well, I know I want cupcakes that taste good, but now I don't know where to go to get them. If it was Dana's cupcakes, okay, that helps me to distinguish these particular cupcakes from someone else's cupcakes, all of which probably taste good. But just delicious cupcakes doesn't help me get there. The flip side of this, the other way to see it, is as an issue of fairness. So if I sell cupcakes and you sell cupcakes, guess what? We both need to have access to that word just to explain to other people what we do, what we have on offer. It's not fair if I get to say cupcakes and I exclude you, and now you have to say baked goods with frosting on top. That's just ridiculous. So that's the kind of wording we're not going to let anyone have exclusive use of. And delicious, this is really just bragging wording. We kind of feel like everyone needs to have access to bragging wording. They should be able to say how wonderful their particular goods or services are. So we're really uncomfortable with the idea of letting one person have access to the word delicious and not letting other people use it. Okay, so the problem here in a mere descriptiveness refusal, I want to be very clear, is not that that particular mark is just horrible and could never be registered. The problem isn't the mark alone. The problem is the relationship between the mark and the goods or services. So just to illustrate this very quickly, if I have my delicious cupcakes mark, but I change my goods, I'm not using it with cupcakes, I'm using it with shampoo. We no longer have a mere descriptiveness refusal. We are fine because cupcakes is no longer telling me exactly what I'm getting. I'm getting shampoo. Cupcakes is a totally arbitrary word when used with shampoo. And delicious, I know that 2020 has been a very strange and unusual year. I hope none of us have resorted to eating our shampoo. It's just not a word that we typically use with those particular goods. So delicious cupcakes with cupcakes, yeah, we got a big problem. Delicious cupcakes with shampoo, we are no longer in mere descriptiveness territory. So it's always the question of that relationship between the mark on one hand and the goods or services on the other. So I'll give you my real world example here. And this was from 2018. And the mark there was smarterhome.xyz. The goods were basically home and office automation systems. And the services were the installation, repair, and maintenance of home and office automation systems. So when we look at this, we're going to kind of break it down into parts. We have to look at the whole mark in total, but we have to break it down into parts to understand what it is talking about. Smart in this context is going to be understood to mean automation or something related to automation. Smarter is just going to mean we know we're making something more automated. And home, now we know what we're making more automated. We're making residences more automated. And when we look down in the goods and the services, we have home automation. Home automation. So it is looking very, very descriptive at this point. And then we have .xyz. Well, does this by any chance get us around this problem? Does this get us out of mere descriptiveness territory? Unfortunately, the short answer there is no, it doesn't. So .xyz or .com, these are both things that are not really source identifying. So consumers look at that and they think, okay, it's a website. They don't look at that particular wording to help them distinguish between one mark and another. So we say this is not source indicating wording, and all of this wording is merely descriptive. Now, when we're trying to figure out if a mark is merely descriptive, we're looking mainly at the identification of goods and services. And so we saw here the home and office automation systems, oh man, with Smarter Home, that's looking really descriptive. Excuse me, I apologize. We're also going to look at how the public and competitors use the wording. So in this instance, one of the first places that an attorney at the USPTO will go is an online dictionary. So you look on this online dictionary and you can see there's actually an entry for smart home. It's a home equipped with lighting, heating, and electronic devices that can be controlled remotely by phone or computer. So it doesn't matter that it isn't smarter home. We know that smarter is just going to mean it is more automated. It is more equipped with these particular kinds of devices. So that's looking really bad for the applicant. And then the USPTO is also going to look at things like general articles, available in any kind of online publication, Seattle Magazine, for example. And they're going to see, all right, if I see this wording smarter home, is it being used to refer to that particular brand? Or is it instead being used descriptively? Is it being used to refer to making a residence more automated? And here there are a bunch of examples from different online publications where they are using that wording descriptively. So those are the things that the USPTO will go to first, dictionary definitions and how this wording is used by other people in online publications. Okay, And then just a quick heads up before we leave this topic, some problematic prefixes specific to this field. E, I, and smart. If you are sitting on a merely descriptive mark and you're thinking, okay, well, we'll get around this, we'll just slap an E on the front or an I on the front or a smart on the front. That is not going to help you, okay? Because in this context, E will be interpreted as meaning electronic, I will be interpreted as meaning internet, smart will be interpreted as meaning automated or related to automation. And so you're really just putting more descriptive wording on top of other descriptive wording, and it's not going to help you to get around that problem. Okay, and now we're going to move on to our very last section before we open things up for questions. And these are three of the issues that pop up all the time, specifically in applications related to the Internet of Things. So we're going to talk about disclaimers and identifications of goods or services and specimens. So starting out with disclaimers, there's a reason why I put this back to back with the Section 2E1 mere descriptiveness refusal. Disclaimers are dealing with a similar situation. Now, if you have a word mark and all of the wording in that mark is merely descriptive, that's when you're going to get the mere descriptiveness refusal. If you have a word mark and only some of that wording is descriptive, but some of it isn't, some of it is distinctive, then you're going to be in the situation of dealing with a disclaimer. There's a few other ways that you can end up with a disclaimer, but this is the most common. So this is what we'll focus on. So what happens in that situation is that you have to disclaim the descriptive wording. Now, a disclaimer does not take any wording out of your mark. Your mark registers in its entirety. But it's just a one sentence statement that goes into the record that basically makes it clear you're not trying to prevent anyone else from using the word technology or electronics or something like that to describe what they do. You're just trying to prevent them from using that particular wording in connection with whatever other wording is in your particular mark. So I'll give you a couple of real world examples. These are all active registrations. We have United Smart Tech. So here I've put the blue bracket underneath the part of each of these marks that gets a disclaimer. So Smart Tech, this particular mark is used with goods that are technology goods related to automation. And so Smart Tech here is descriptive. So that does not mean that we take Smart Tech out of the mark. The mark registers as United Smart Tech, but there's just a one sentence statement in the record that says no claim is made to the exclusive right to use smart tech apart from the mark as shown. Just making it clear, you know what, we understand other people who are selling technology goods that are related to automation, they may need to use this phrase smart tech as well. We're not trying to prevent them from doing that, but they just can't use smart tech with the word United. Okay, so that's how this works. A couple more examples. Lifestyle Evolution Inc. Okay, so this is a little bit different because Inc. is not describing the goods or services, but it is indicating that the company that sells these things under this mark is a corporation. Well, a whole lot of companies need to use the wording Inc. or corp or corporation or co or company. And we're not going to grant exclusive use of Inc. or wording like that to any one particular company. Everyone who wants to use that particular Inc. abbreviation in their mark has got to be able to do it. So there's a disclaimer for that. Inco Electronics, used with electronics goods. So you get a disclaimer there. And then finally, Nest Cam. Well, we know in this particular situation that CAM is an abbreviation for camera. So just because it's an abbreviation doesn't get us around the requirement. In the same way that tech is an abbreviation for technology. So CAM for camera, this is going to be disclaimed as well. Okay, last thing to look out for with disclaimers, laudatory terms. Now, laudatory is the word that the USPTO will use, but I would just say bragging words. Look out for bragging words. Things like best, or if you're a little bit more humble, good. But any of these, this is not an exhaustive list. These are just from cases that, I could pull up really quickly to say this definitely is considered a laudatory term that you would have to disclaim. So things like this, where you're just saying how wonderful your particular goods or services are. Well, we want everyone to be able to brag about how wonderful their stuff is. So you'll have a disclaimer for that type of wording as well. And again, it's just going to be no claim is made to the exclusive right to use best apart from the mark as shown. Just making clear other people can use the word best and you're not going after them for that. All right, so our second topic here is the identification of goods and services. And you remember when you file your application, you have to tell the USPTO what you are using this particular mark with, which goods or services. And you also have to put it into the correct class out of those 45 classes of goods or services. So here we have two main concerns. Our first is the wording definite. Our second are the goods or services in the correct class. So when I say definite, I just mean, is it clear to me what you are doing, what you are selling? Understand that definite for the USPTO's purposes is not the same as definite in just an everyday normal conversation. If you and I are sitting down having coffee and you tell me you sell clothing, I absolutely know what you are doing. If you tell the USPTO you're selling clothing, they want more specificity. So, definite to them is not the same as definite to you and me in casual everyday conversation. You can have both of these problems at the same time. So I'll give you a couple quick examples of how that might work. We call these overly broad and indefinite identifications. Software is a really common one. People often will just type software in and submit that. And that's a really fast route to a refusal. So there's a couple of things going on here. First of all, we always need to know the function of the software. For what? What does it do? Database management, home automation, whatever the case may be. But I need to know what the function is. And also we need to know, is this software either recorded or downloadable like a mobile app, or is it non-downloadable like our cloud-based software? That's going to help us figure out what class it goes in. So you'll remember really quickly, I'll just repeat from the beginning of the presentation that we're in class 9 if it's downloadable or recorded software used for any function at all. If it is non-downloadable software and it's for a game, we're in class 41. And if it's non-downloadable software for any other function, any other purpose, it's in class 42. All right, so just the word software, I don't know what it's for. I don't know what class it belongs in, if it's downloadable or non-downloadable. So it's overly broad and indefinite. We have a similar situation down here. If you just type in something like smart home automation, I have no idea. Is that a service or a good? Are you saying like you install smart home automation systems? Are you saying that you sell smart home automation systems? What exactly is the good or the service? We don't know what class it belongs in. So here's some sample acceptable wording, which is going to combine both of these things actually, but it will help to just see how specific you need to be. So if we have smart home automation, namely downloadable mobile applications for home automation and control of digital sensors and transceivers, guess what? Now I know what smart home automation is. It's a good, it's software, specifically it's a mobile application. And I know that it's downloadable, wonderful. The only thing I need to know now is the function, and I've got that. It's for all of this. So that's the level of specificity that the USPTO is looking for with these kinds of goods. Okay, my last note on IDs before we move on is avoid technical verbiage. And I'm being kind of tongue-in-cheek by saying verbiage. All I mean is just use small words where you can. Don't go for the big word to try and impress anyone. This is one of the big differences between patent applications and trademark applications. The patent application is super technical and has to explain every little detail of how your particular product is functioning. The trademark reviewer does not want to see all of that language. They cannot deal with that. It actually has to be written in a way that the average person can understand what your goods or services are. So if you put a whole bunch of technical jargon in there, you're going to get a refusal and you're going to be told you have to put this in simple, plain terms. So just when you're thinking about that, think about writing it so a 5-year-old could understand what you are doing. Okay, don't write your trademark application as though it was a patent application. And then lastly, we'll talk about specimens. So A quick reminder here, we talked about this in answer to a question as a little bit of a detour, but a specimen is just the proof that you submit to the USPTO that you actually are using your mark out there in the real world marketplace. So this could be a screenshot of your website with the logo on it. It could be a photograph of your product packaging with your logo on it, something like that. Those are just two examples. There are many things that can function as specimens. But basically, it's just showing the USPTO, okay, here's how consumers in the real world encounter my mark. So there are two issues that pop up all the time in applications of this kind, and that's mock-ups and printer's proofs. Is your specimen a one-off or a graphic designer's rendering of product packaging? Well, the one-off is a mock-up, meaning let's say that you are selling thermostats, or you're going to. Now, you might be having some problems with your manufacturer right now. A lot of people are during COVID. So maybe you thought your specimen was going to be ready and it isn't. And now you're coming up on your deadline to submit your specimen and you don't have it. So you just take a box and you slap a label on it with your mark on that label, and you take a picture of that and you send it to the USPTO. Okay. They are not going to be happy with that because, again, the specimen is supposed to be how consumers encounter your mark in the real world marketplace. Well, consumers aren't even encountering your mark yet. These things are not actually for sale. And so that's not going to work as a specimen, okay? It has to be something that consumers really are encountering in the real world marketplace. And printers proofs, it's easiest if I just give you a quick example of what this looks like. And basically, it's just the design that your graphic designer comes up with and sends to you, okay? So the dead giveaway are these corners and the color scale, and sometimes there's even a message from the graphic designer to the client here. Well, again, the problem is we don't know that any consumer has ever actually seen this. We know you've seen it, your graphic designer has seen it, but for all we know, you hated it and you told them, go back and make a new label. So we don't know that this was ever on a product that your clients or consumers ever saw. If you are actually using this label, then yeah, take a photograph of the label on the product packaging that you are actually sending out to the people who buy your stuff. That's fine, but do not send something like this. Just 10 times out of 10, it will be refused. So I want to open things up now for questions. I know I dumped a lot of information on you. And as was mentioned before at the very beginning, this is a time for general questions. So anything about trademark law, the application process, anything I've covered so far in the presentation. For specific questions, I'm happy to talk to you about those one-on-one. And you can contact me by either of these means. I just can't talk about really specific things like an application you're about to file or a refusal you got or anything specific to your particular circumstances because of confidentiality reasons, again, as was explained at the beginning. So happy to talk to you about that kind of thing one-on-one, but now is a perfect time for general questions.
Thank you, Dana. That was an amazing presentation. That was super helpful. Before we move on to the Q&A, I would like to remind everyone to take a minute to fill in the survey so that Temple SPDC can help small businesses and help them to grow further. Let's begin with the Q&A. If anyone has any questions, feel free to drop them in the Q&A chat box. The first one is it possible to do a name search by myself before filing for a trademark?
Okay, so you can try that. The USPTO does have a free tool on their website. It's called TESS, T-E-S-S. A heads up on how TESS works, though, and this is a limitation that a lot of people are not aware of. So TESS is very, very literal. Okay, TESS only searches for exactly what you tell it to. Nothing more, nothing less. When you type something in Google and it's like misspelled by one letter or something, Google will say, oh, did you mean, it's very helpful. Okay, TESS is never going to ask you what you meant. TESS just searches whatever you tell it to search. In a lot of instances, when you are doing your search and test, unless there is a mark that is identical to yours, TESS is not going to pull that up. Now, there is a type of search code that you can use that will help you to pick up marks that are spelled slightly differently, marks that sound the same. But that, I think there's only one page that I know of on the USPTO website that explains a little bit about that code. And it really just tells you the basics of it. It doesn't tell you too much about strategy or sort of more sophisticated ways of using it. So people who have worked at the USPTO, they can use TESS and use their code that they learned in training there to find marks that are similar. But for other people, unless you just have time to teach yourself about this code, it's a tool of limited utility. It's really only going to pull up exactly what you ask it to. So yes, there is that tool available, but just a heads up, a warning about it. It's of limited use unless you know how to do the particular search code that it uses. It's not very user friendly, and I don't think there's any plans to update it and make it more user friendly.
We have the second one. If fabric is trademarked and people use it to make other products, i.e. masks, will this be an infringement if the person sells the mask along using that fabric?
Okay, so I'm not 100% sure that I understand exactly what the question is, and it may be one of these ones that's a bit more specific, but basically, just speaking really generally, the likelihood of confusion, you're looking at how similar the marks are, and then how closely related those goods or services are. So, and it's a sliding scale. If you have marks that are identical, then you don't need quite as much relatedness between the goods or the services. If your goods or services are identical, then the marks don't have to be quite as close. So without knowing the exact situation there, basically, it depends on how close the marks are, whether goods that maybe are a little bit further apart would be considered related enough that there was a likelihood of confusion. That's a really, really general answer to the question.
We have one more in the chat. What categories are logos in?
What categories are logos in? So a logo, do they mean like class? A logo can be used with any class of goods or services. A logo is just one particular kind of mark. So you have basically two most common types of marks. There are other things that are used as marks, but one is called a standard character mark. That's where you're just protecting wording. And that's the broadest possible protection that you can get for a wording mark. So, Dana-Dixon law, if I want to protect that, if I register that as a standard character mark, I can use that wording in any font and any stylization and any color that I want. That's totally fine. It gives me the maximum amount of flexibility. If I have a mark that has any kind of design element at all, then we're talking about a special form mark. So that could be a mark that consists entirely of a design, no wording, like the famous Nike swoosh, or it could be a mark that has a lot of wording, but also many other design elements in there. So the special form mark, you are getting a registration to use that mark exactly as it appears, okay? The exact design elements and or wording in the exact arrangement in which it appears. If you upload a drawing of that mark in color, you're also stuck using those exact same colors. If you upload your drawing in black and white, but you don't claim color, then you can use that design in any color scheme that you want, but you are still stuck with those particular design elements in that particular arrangement. But either one of these kinds of marks, the standard character or the special form, you can use them with any kinds of goods or services. You can use them with any class in those 45 classes.
Okay. So the next one is, what would be the price range to hire someone to submit the application for you?
Okay, so it can vary widely, all right? You should be able to find someone who is competent and knowledgeable in this field to file an application for you from, the initial search, filing through to registration for less than $1,500. That's, one application, one class of goods or services. There are definitely people who will charge more than that. But you can do your due diligence, do your homework, search around, and you should be able to find someone who would do that for you, who knows what they're doing, for less than $1,500. Now, I would say, just kind of on the general topic of talking with attorneys, you do want to make sure whoever you engage to do this work for you can actually take that off your plate. And you would not have to worry about it anymore. So you want to make sure that they are knowledgeable in that field. I will tell you from reviewing a lot of applications, many bad applications are filed by attorneys who I'm sure were telling their clients they knew exactly what they were doing. So exercise caution. And I'm not saying to be belligerent or insulting to your potential attorney, but when you're talking to someone about hiring them, you can ask a totally neutral question like, what percentage of your work is trademarks? That's totally neutral. That's not going to offend anyone. But it's helpful information for you to figure out whether they actually are experienced in this field and can handle this process. So, it's like if you had to have a heart surgery, you would ask the person who's going to perform that surgery, like, what percentage of your work is heart surgeries? And if they were like, well, I mostly do feet, but every now and then I throw a heart surgery into the mix, like, you might want to keep on going, right? In medicine, as in law, like, specialization is very, very important. So I would say definitely try to do a little bit of research on whomever you would consider hiring, and just make sure that they know what they're talking about, because you don't want to make that investment to sort of subsidize their on-the-job learning, right?
Okay. Thank you for that. The next one is, at what level are most businesses successful at gaining an approval, and what is the average amount of submittals?
The average amount of submittals. Okay, so speaking very generally, the average amount of submittals, I think there were over 600,000 trademark applications filed with the USPTO last year, last fiscal year, which ended in September. And so it varies a little bit from year to year, but that gives you some idea. And when I say with the USPTO, there are trademark offices around the world for protecting trademarks in different locations. So they have widely variable numbers of submissions, but within the US, over 600,000 in the past year. And in terms of at what level businesses are successful, so it doesn't make any difference to the USPTO whether you are a big company, whether you are a medium-sized company, whether you are one person with a big dream. They don't really care. They're not looking at your balance sheets or anything. They are really just looking at the drawing of the mark itself, or what the wording of the mark is, whether someone else has already registered that in the past, and whether your mark is descriptive, whether your mark functions as a trademark, is it actually a source identifier? So they're concerned with those technical and legal aspects of the application, but they really don't do any research into how big or small you are. That does not come into play at all.
Mm-hmm. Someone wants to know if
Divya?
Yeah.
So we are past the 1 hour mark, so I want to allow anyone who needs to head out that they can do so. Just make sure to take that survey that was posted in the chat. Remember, this is required by our funder, so it's important that we have that information for you. And we also included a link to our resource page. This is updated almost daily and has a library of previous webinar recordings. We record most, but not all of our webinars, so that would be the place to find them, as well as our YouTube channel. It also contains links to sign up for other webinars that we have coming up. And we do actually have a focus on legal matters this month. So if you enjoyed this, we have a legal formation workshop in 2 days. And if you are at that stage and kind of an early stage and have not actually formalized your business yet, and then we also have a legal essentials for doing business online on the 14th. That'll talk about compliance issues. I wanted to point those 2 out, but we have several in December and many in the new year. So I will pause the recording for now. I will say big thank you to Dana. We've gotten a lot of positive feedback. We'll stay on for a few more minutes, but I just wanted to say thank you for joining us, and thanks so much to Dana for today's great presentation.
Yeah, thanks.